Welcome to this presentation on Illinois Senate Bill 2288. This bill would abolish all DEIA programs across Illinois state government. Illinois Senate Bill 2288 was sponsored by Senator Andrew Chesney, a Republican from Freeport, introduced on February 7, 2025. The bill targets every department within Illinois state government, requiring abolition of all DEIA programs, the Office of Equity, and the Commission on Equity and Inclusion Act. As stated on the Illinois General Assembly website, the bill has no co-sponsors and is stalled in committee. So, what exactly is SB 2288? It is a state bill that would require every Illinois State Department to abolish all DEIA programs, offices, and positions. According to the official text at ilga.gov, departments may not enforce any policy that favors or discriminates based on race, sex, or disability, beyond what federal law requires. The bill targets the Office of Equity, the Commission on Equity and Inclusion, and all DEIA programs in every state department. Federally required programs like ADA, Title VI, and Title VII would remain intact. Let us examine the 5 core provisions of SB 2288. 1. Abolish all DEIA programs in every state department. 2. Abolish the Office of Equity, which coordinates DEIA strategy across Illinois state government. 3. Repeal the Commission on Equity and Inclusion Act, ending the Business Enterprise Program for minority-owned and women-owned businesses. 4. Ban preferential or discriminatory policies based on race, sex, or disability. 5. No state funding for DEIA programs, training, or staffing. Follow the QR code on this slide to review the full bill text. Who would be affected by SB 2288? Every Illinois State Department, agency, board, and commission would be required to abolish DEIA programs. The Office of Equity, which coordinates DEIA strategy across state government, would be abolished. The Commission on Equity and Inclusion and its Business Enterprise Program for minority-owned businesses would also end. Federally required programs like ADA compliance, Title VI, Title VII, and Veterans Preference would remain intact. SB 2288 is part of a massive national wave of anti-DEI legislation. According to the Chronicle of Higher Education, over 80 anti-DEI bills have been introduced across 30 states since the Supreme Court decision in Students for Fair Admissions versus Harvard in 2023. Florida led with SB 266 in 2023 and SB 1134 in 2026. Texas passed SB 17 in 2023. North Carolina, North Dakota, Tennessee, Utah, and Iowa have all enacted similar laws. At the federal level, President Trump EO 14151 shut down federal DEI programs in January 2025. Follow the QR code for the Chronicle DEI tracker. Illinois SB 2288 has the broadest scope of any anti-DEI bill in the nation. Florida SB 266 and SB 1134 target universities and local governments. Texas SB 17 targets public universities. Most states focus on higher education, but SB 2288 targets all state departments and would abolish the Office of Equity and CEI Commission entirely. However, most anti-DEI bills passed in Republican-controlled legislatures. Illinois has a Democratic supermajority, making passage unlikely. As Joshua Atkinson wrote for fightingforfreeport.com, quote, SB 2288 is performative legislation with no path to passage, end quote. Let us walk through the timeline. In June 2023, the Supreme Court ruled in Students for Fair Admissions versus Harvard, ending race-conscious college admissions. In January 2025, President Trump issued EO 14151, shutting down federal DEI programs, and rescinded EO 11246, which required affirmative action since 1965. On February 7, 2025, SB 2288 was introduced and referred to the Senate Assignments Committee. Since then, no hearings, no amendments, no votes. The bill is stalled indefinitely with no co-sponsors. Why is SB 2288 stalled in committee? First, the Democratic supermajority. Illinois has strong Democratic control of both chambers. Second, no co-sponsors. Senator Chesney filed this bill solo. Third, no committee action. The Senate Assignments Committee has never scheduled a hearing. Fourth, Governor Pritzker established the Office of Equity and would likely veto any repeal. Fifth, this is widely viewed as a messaging bill designed to make a political point rather than become law. Let us consider the arguments for and against SB 2288. Supporters argue DEIA programs are costly and ineffective, that government should be race neutral, and that federal anti-discrimination law is sufficient. Opponents argue DEIA programs address systemic barriers, that the Office of Equity coordinates necessary inclusion efforts, and that the BEP program supports minority-owned businesses. Without these programs, opponents say, disparities in state employment and contracting will widen. What would actually change if SB 2288 passed? The Office of Equity would be abolished. State-level DEIA coordination would end. The CEI Commission and its business enterprise program would end. Minority-owned and women-owned businesses would lose preferential contracting status. However, federally required programs like ADA compliance, Title VI, and Title VII would continue. Legal challenges from equity advocates would likely follow, and there could be implications for federal funding. Let us place SB 2288 in the broader legal context. At the federal level, EO 14151 ordered all federal agencies to terminate DEI programs. The EEOC and DOJ have suggested DEI training may constitute discrimination under Title VII. At the state level, over 80 anti-DEI bills across 30 states since 2023. Most focus on higher education, but Illinois SB 2288 would be the broadest. Court challenges to state anti-DEI laws are pending. The 2026 midterm elections could reshape the landscape. Follow the QR code on this slide for Texas SB 17. Let us summarize the key takeaways. Number 1. SB 2288 would abolish all DEIA programs, the Office of Equity, and the CEI Commission across Illinois state government.